In this video, we're going to be taking a look at how the former Memphis police officer, Demetrius Haley, was able to get his previous complaint against him, the civil rights violation, tossed. And usually this happens through a motion for summary judgment, which he made, and then the court then ruled on. And let's take a look at it to see how he was able to get the court to rule in his favor. Just to give you some background as I'm pulling this up, a motion for summary judgment is usually done in every case. If you're representing someone, even if it's not a criminal complaint, even if it is just a civil complaint, after the other party has had a chance to present their evidence, then if you don't feel like they have met the burden, then you can then say to the court, hey, I'm going to file a motion for summary judgment because I don't think that they've met the standard that they were supposed to meet. And in this case, because these allegations were, these were criminal allegations. So you're not just going to, say, hey, we're just going to make a motion. No, you're going to provide a lot of information as to why you should be granted this motion. So they did file a motion. This is the order that the judge said, hey, here's why I'm ruling the way that I'm ruling. And ultimately, the complaint was dismissed. So here you have here, and this is about 9 pages. I'm going to try not to get too much into the legal side of this, but I do want you to understand that there were some technical reasons why this got tossed. This was not something that the parties went into court and they argued what happened in the bathroom, and they argued what happened in the bathroom, and then the judge or the jury went through all the witnesses and heard all the information and then came to a decision. That is not what happened here. So this was not some sort of ruling based on what actually happened. This was a ruling based on some other things, most of it having to do with process. So what you see here is the actual order. It's about 9 pages. And remember, the incident happened in 2015. I think the complaint may have been filed in 2016. And this is in the Western District of Tennessee, in the United States District Court. There you have the plaintiff, who was Cordarlrius Sledge. He was the party who was saying that they had done harm to him. And then you have the defendants, and Demetrius Haley is the one who is a part of the team that has been accused of beating up Tyree Nichols. So this is an order granting defendant's motion for summary judgment, withdrawing the court's reference to the magistrate judge, and denying defendant's motion to compel as moot. What we're really interested in is this part here that talks about granting defendant's motion for summary judgment, where they have said, hey, we think this should just be dismissed now. All right, so it says, before the court is the motion for summary judgment of defendants David Dyson and Demetrius Haley. Plaintiff Cordarlrius Sledge filed his pro se complaint, meaning he's representing himself, alleging defendants corrections officers at the facility in which he was imprisoned violated his civil rights. Defendants now seek the dismissal of all claims brought against them in that complaint because plaintiff failed to exhaust his remedies as he was required to do under the Prison Litigation Reform Act. Plaintiff has filed no response. So they filed a motion saying, hey, he didn't do this process right. And the plaintiff did not respond. It says, for reasons set below, the instant motion is granted. Okay. Let's go into the background here so you can understand this procedure that they're talking about. Plaintiff filed his pro se complaint on April 19th, 2016. The court is required, I think that's supposed to be to screen prisoner complaints, dismissing them or portions thereof if they are frivolous or otherwise fail to state a remediable claim for relief, meaning the court can actually do something. The court screened plaintiff's complaint in this case, dismissing one defendant in its April 26 order. And in doing so, the court also ordered that process be served upon the remaining defendants. Not long thereafter, Defendants filed an answer, and that was one I did in the other video, the last video about this. Not long thereafter, defendants filed an answer to the pro se complaint. On October 24, 2017, defendants filed the present motion. Plaintiff, however, did not file a response. Despite the fact that the period to respond had long since elapsed, the court gave plaintiff another chance in its January 3rd, 2018 order, warning plaintiff that failure to respond would result in the court regarding defendant's statements of facts as undisputed in its entirety. Plaintiff still has not responded. Let me talk about that for just a second, because here's what happens. So if I file a motion saying, hey, that's not what happened, here's what happened, they didn't prove things, they didn't do the right process, therefore we believe this whole thing should be dismissed, okay? Because here are our facts and here's what they didn't do. If you don't respond to that, then the judge can just go with their story, okay? And that is what the judge said here. The judge said, I'm going to give you an opportunity. The timeline has expired. The deadline's gone, okay? But I have some discretion. I'm going to give you an opportunity to respond. And he says plaintiff did not respond. And remember now, this is really hard to do and I say really hard to do, but that's relative, depending upon how adept you are with understanding what these filing requirements are and what you need to do. We can't assume that lay people have a good understanding of this. And so it can be really hard sometimes for someone who is in prison to get the assistance that they need to even carry some of these things out. But let's go on and see what the undisputed facts are. Okay, undisputed facts. The following facts are undisputed by the parties. It says plaintiff was an inmate housed at the Shelby County Division of Corrections. It says plaintiff alleges that certain officers employed by the DOC, including defendants, assaulted plaintiff while he was an inmate. Plaintiff further alleges that this incident occurred on May 16, 2015. DOC policy 323, this is important, governs the submission by inmates of complaints or grievances concerning actions by staff that negatively affects inmates. The version of policy 323 that was in effect at the time of the incident took effect on April 27, 2015. So this policy had been around for a little bit. The rules governing this particular one, the rules governing inmate grievances as explained in policy 323 are included in DOC inmate handbook. Each inmate receives an inmate handbook upon arrival at the DOC. The grievance process is available to every inmate. The grievance process was available to plaintiff on and after the date of incident. Grievance forms and submission boxes for those forms are located throughout the prison and are available to all inmates. And then they talk about what kind of grievance his was. It was a confidential grievance. So then it says policy 323 requires inmates to submit any grievance, including confidential grievances, within 30 days of the alleged incident giving rise to the grievance. An inmate must sign and submit his own grievance form. 30 days is not a lot of time. If there's something that has happened and you maybe want to find an attorney to assist you with it. Now, remember, you're in prison. So it's not like you can just decide on your own. Okay, well, now I'm going to find this attorney. I got a whole list I can go through. I've got, access to resources anytime I want to be able to find this attorney. So it's going to take you a while. It takes people who are not in prison a while to find an attorney. So 30 days, just from me listening to this, sounds like a really short period of time to possibly get assistance, to make sure you file a really good complaint that has all of your information in it, and you sign it and you send it in. Now, if you saw my original video on the complaint, then you heard me talk about how I felt like the complaint could have had more information in it. But it's hard if you're not an attorney, you're not a law student, you're not a paralegal, you're not somebody who studied this, for you to know what you should be putting in there. And so you think you're describing exactly what you're supposed to be describing, and you are, but there are probably some additional things, some ways you could have said it that could have helped you. And usually that's done best when you have an attorney who can help you do it. So 30 days, just in my personal opinion, is not really a lot of time, but it is a step that is absolutely required. Really can't skip it, okay? Really can't skip it. So they've put this in here to make a really big deal out of it, to let you know this is required. Here was the policy. He was given the policy. The policy was in the handbook. He was given the handbook. So yes, it was available to him. So it says on May 27, 2015, plaintiff submitted an appeal of discipline against him stemming from the incident. Plaintiff's submission was an appeal of a decision to administer discipline. Okay, so this had to really do with discipline. And really, his complaint was supposed to be about the actual injury and what had happened to him, the civil rights violation. Plaintiff sent a letter dated February 29, 2016 regarding the incident, which the department received on or about March 3rd, 2016. Plaintiff sent a second letter dated March 7, 2016, which the department received on or about the same day. In addition to plaintiff's letters, several other inmates sent a letter dated May 19, 2015 about the incident to DOC Director William Gupton, attorney Arthur Horn, the DOC's Office of Professional Standards, Fox 13 News, Mayor Mark Luttrell. Plaintiff did not sign this letter. Plaintiff submitted no other grievance documents regarding the incident. Okay, so what's the standard of law here? And this is just talking about when deciding a motion for summary judgment, because Demetrius Haley's attorney, they put together a motion saying we think this should be dismissed, and here's why. It says when deciding a motion for summary judgment, the court must review all the evidence, viewing it in a light most favorable to the non-moving party. So this had to be looked at most favorably toward Mr. Sledge, okay? Not Mr. Haley, Mr. Sledge. What's most favorable for Mr. Sledge? And also says, and also drawing all reasonable inferences in that party's behavior. The burden is generally on the moving party, Mr. Haley, to show that no genuine issue of material fact exists, but that burden may be discharged by showing that there is an absence of evidence to support the non-moving party's case. All right, so I want to move down here to the analysis, because this is really the important part. So now you understand there was this process there. This is what Mr. Sledge did, and Mr. Haley saying this should be dismissed. Plaintiff's pro se complaint is captioned as complaint for violation of civil rights under 42 U.S. Code Section 1983. Plaintiff, Mr. Sledge, alleges that the defendants, Mr. Haley and others, entered the area he was located in for a random search because they claimed to have seen smoke. Plaintiff was then strip searched by defendants. Plaintiff says that defendants claim plaintiff tried to flush contraband immediately preceding or during the search. Then, according to the allegations of the pro se complaint, defendants Haley and McLean punched plaintiff in the face. Defendant Dyson picked plaintiff up and slammed him face first into the sink and then the floor. Plaintiff claims to have then lost consciousness, waking up in the institution's medical center. Plaintiff ultimately seeks to have defendants held accountable for their actions. Defendants, okay, Haley and others, move for summary judgment solely on the basis that plaintiff has failed to satisfy the exhaustion requirements set forth in the PLRA. And it says here, plaintiff, despite entry of a show cause order, has failed to respond. Plaintiff's failure is not, however, good grounds for granting the motion. Therefore, the court is given the difficult task of considering defendant's motion on the merits without the crucible of meaningful adversarial testing, meaning the other party hasn't come here. It says the dilemma thereby created for the court playing devil's advocate on behalf of the disinterested party because he did not respond, while at the same time attempting to exercise its impartiality in making a just determination. It says, yet a determination on defendant's motion must be made. So the court is saying, hey, he's not here. I have to look at this in a light most favorable to Mr. Sledge, who's making this accusation, but I have to make a determination because they have filed this motion. So let's talk about the PLRA and what is actually required. It says here, Generally speaking, and let me just scroll down, okay? No action shall be brought with respect to prison conditions by a prisoner confined in any jail, prison, or other correctional facility until such administrative remedies as are available are exhausted. So remember that whole policy, that's the administrative remedy that they're talking about. And then they give you all of the case law behind it. It says the PLRA's exhaustion requirement applies to all inmate suits about prison life, whether they involve general circumstances or particular episodes, and whether they allege excessive force or some other wrong. It says all available remedies must be exhausted. Those remedies need not meet federal standards, nor must they be plain, speedy, and effective. If a prisoner fails to exhaust his remedies, no action can lie. And the Supreme Court has likewise been clear that the remedies available are determined by the procedure of the institution in which the prisoner is housed. So think about that for a second. A prisoner in one institution might have different policies and rules than a prisoner in another institution. But whatever those rules are, those rules have to be followed before the person can then say, hey, I'm going to file this other complaint. You've got to jump through the institution's process first. Okay, so that is what the court is laying out here. Let's go back. Now, whether plaintiff, Mr. Sledge, timely filed a grievance. Defendants, Mr. Haley and the other, assert that the department received no timely grievance from plaintiff. It says, if correct, this is sufficient cause to dismiss plaintiff's claims for failure to exhaust his remedies, because the Supreme Court has held that missing a deadline set by a grievance policy is indeed a failure to exhaust available remedies. Think about that again. He missed the deadline for meeting policy 323. Policy 323 required plaintiff to submit his grievance within 30 days of the incident. The court will examine the communications received by the department in the light of policy 323 to determine if any communication was proper and timely. So the court's now going to look at this and say, did you meet that 30-day timeline? According to the undisputed facts, it says defendants received one, an appeal of discipline from the plaintiff, 2 letters from plaintiff seeking information about the investigation into the incident, and a letter from other inmates concerning the incident. So those are the 3 things that the court's looking at. It says defendant's statement of facts. It says while within 30 days of the incident, the disciplinary appeal, it was within those 30 days, but it says the disciplinary appeal cannot constitute a grievance under policy 323 because the policy expressly states that a disciplinary appeal is not a grievance. Therefore, the disciplinary appeal does not constitute a properly filed grievance. So that kicks that out, okay? Plaintiff also sent 2 letters to the department in February and March inquiring about the investigation. And it says here, defendants note that these letters did not comply with the policy either, okay? It says because they were sent more than 30 days after the incident. So now that's 2 gone, okay? So first, it was a disciplinary filing, and that's not, that didn't meet the requirement. And then it says you sent these other letters, but they weren't sent within 30 days. So that didn't meet the requirement. The letters sent on February 29, 2016 and March 3rd, 2016 fall well outside of the 30-day period that began May 16, 2015. Therefore, the letters were untimely under policy 323 and cannot constitute a properly filed grievance. Finally, here's that 3rd one. Several other inmates sent a letter to the DOC director and other individuals on May 19th, 2015, well within the 30-day period. So here's one that might get through. However, policy 323 is clear. An inmate may not submit a grievance on behalf of another inmate. And although an inmate may assist another inmate in preparing a grievance, the complainant must sign the grievance and submit the form. Here, Mr. Sledge did not sign the letter from the other inmates. Thus, this letter cannot constitute a grievance either. And the court must conclude that plaintiff failed to exhaust his remedies since he did not properly file a grievance as required by policy 323. Because plaintiff failed to exhaust his remedies, the PLR precludes his filing of this action, which means he can't file this action. Okay. The court therefore finds no material facts remain in dispute and defendants are entitled to judgment as a matter of law. So therefore it says, for foregoing reasons, defendant's motion is granted and Mr. Sledge's claims against defendants are dismissed. Okay. There's something down here that does talk about an exception there, but now you have an understanding of what actually happened there. This is one of those things where people like to say, okay, so this was basically a situation where there were some technicalities. There was a process that was not met. And so there was never any judgment on the merits of the case. No, like I said before, nobody was ever saying, okay, well, show up. Do you have witnesses? Tell us your side. You tell us your side. And now we'll make a decision. No, that didn't really happen. What happened was he was supposed to meet this process that was outlined in the policy, which was file a grievance within 30 days, sign it, and submit it. And while there were 3 times that something had been filed, each one was deficient for some reason. And so that allowed for the case to get dismissed. So these timelines are crucial. These policies are crucial. And I doubt very seriously that he understood that would kick him out of getting any sort of remedy or even really getting into court to even talk in front of a judge or a jury about his case and what happened. So those sort of technicalities, that process, it's one of those things that you really have to keep in mind. And again, it's why in this case, if you look at it, 30 days is not really enough time. And also why you need legal assistance to help you understand some of these processes that you may not know about. So I hope that brings you up to speed. My battery's really loud. I hope that brings you up to speed with understanding how that case got dismissed. Give the video a thumbs up. I know sometimes people are like, I'm giving this video a thumbs down because I hate that it got dismissed. But I'm just asking you to give a thumbs up if you now understand what happened in that case, even if you don't disagree with it. If you disagree with it, let me know in the comments. Do you think 30 minutes? Do you think 30 days is too short? I think 30 days is too short. That's not enough time. I just think it's too short. So maybe that's one of those areas for reform. I don't know. And each institution gets to come up with its own policy. I can sort of understand that piece. I just think that there ought to be more time there. And don't forget to subscribe. Peace.